Hello, and welcome back to another episode of DW Fast Track, the podcast where lawyers discuss all things legal, admissible, and trending. I'm your host, Caleb Green, an attorney in Dickinson Wright's Las Vegas office, focusing on intellectual property law. In today's episode, I will be discussing the recent rebrand of Twitter's social media platform to X. Specifically, I'll be talking about the intellectual property considerations that Twitter may be facing as it undergoes this transition from the iconic bird logo and Twitter name to the X logo. Most importantly, there are many lessons trademark owners and companies can take away from this social media company's recent efforts to rebrand its image. So let's get into it. On July 23rd, 2023, Twitter's owner, Elon Musk, announced that Twitter would be rebranded, replacing its iconic name and bird logo to a new brand that would simply be called X. That same night, Twitter's headquarters building was adorned with a large projection of an X symbol, which Elon Musk shared in a tweet. And according to several reports, the transition from Twitter to X reflects a step towards Musk's goal to turn the platform into what he has called an everything app. Now, Musk owns a lot of other ventures, many of which use some primary form of the letter X. One of the most prominent examples is SpaceX, which is one of Elon Musk's companies that help design and rebuild reusable rockets and spacecrafts out of California. Now, on July 24th, 2023, the Twitter logo was removed from the official Twitter account and replaced with a stylized X mark. Linda Yaccarino, who became the chief executive officer of the social media platform last month, confirmed the platform's rebrand to X in a series of tweets. Now, if you've been paying attention recently, Twitter's business has been suffering, so it may have been time for the company to embrace a fresh new look for the brand. In fact, Twitter's rebrand comes as Twitter has been struggling with several business aspects, including declining user traffic, loss of half of its top advertisers, and plenty of employee attrition. The social media website is saddled with roughly $13 billion worth of debt that it took on during its acquisition of Elon Musk, which was finalized in October 2022. But this raises a lot of questions with how companies will approach the rebrand process. Namely, has Twitter rebrand efforts happened too fast? Does adopting the new X logo open Twitter up to intellectual property liability? And if so, what kind? And what happens to the iconic Twitter and bird logo trademark rights in this rebrand process? Let's first start with the rebranding and IP considerations. Now, when a company is considering opting in for a new look or a fresh start, the owner may consider rebranding the business. This can include adopting a new color scheme, embracing a new design to the company logo, or even creating a new or different name altogether for the company or its products. Now, a company's brand is tied directly to the company's reputation and can impact how the public perceives its goods and services. So it's not surprising that adopting a new brand, a new business name, or trademark would fall squarely under the jurisdiction of trademark law. Just to be clear, trademark law deals with distinguishing goods and services from one another in the marketplace. At its core, trademark law's number one purpose is to protect consumers from marketplace confusion. Namely, trademark law aims to ensure that the public can determine the source of certain products and services that they may perceive in the marketplace. In the United States, generally, trademark rights are created as soon as a company or an individual starts to use a name, a symbol, design, or sound, or even a combination of any of those in connection with offering some forms of goods or services. However, for a trademark to be protectable, it must first be distinctive, meaning the public must perceive it to be a trademark. Then and only then will a trademark or mark be considered have trademark rights in the marketplace. Once a trademark has been established, one big consideration to consider in the rebranding process is trademark infringement. Now, trademark infringement can occur when a company adopts a mark or design that is identical or even confusingly similar to an existing trademark, company name, or logo. This is why trademark attorneys like myself encourage companies to conduct a trademark clearance search prior to adopting a new brand name. In the case of Twitter, its fast-paced rebrand may lead Elon Musk and the company to trademark liability. In addition to the trademark infringement concerns, Twitter's rebrand also raises concerns of potential copyright infringement liability. Now, the X logo that Twitter has adopted in its rebrand is identical to an existing Unicode X character that has been widely used in textbooks and literary works since the 1970s. Without a license from the creators of the Unicode X character, Twitter could be facing significant copyright infringement liability, which can carry statutory damages all the way up to $150,000 per infringement. Twitter's rebrand also raises questions about what happens to Twitter's iconic name and bird logo. Now, trademark rights, just like other intellectual property rights, can be abandoned when the trademark owner ceases to use the trademark with no intention of using the mark again in the future. When a trademark is abandoned, the trademark owner may no longer claim rights to that trademark, and this includes stopping others from adopting that trademark or using it. It is still unclear if any remnants of Twitter's brand will remain amidst the company's rebrand to X. Currently, Twitter boasts hundreds of trademark registrations in the US and in other foreign jurisdictions. But if the company is truly moving away from its iconic Twitter name and logo, this could mean that the company is now abandoning the goodwill and trademark registrations to the public domain. This means all the time, money, resources that the company put in to building its brand, its reputation behind the Twitter name and its iconic logo will be lost. And it may be that the public may be able to use them freely. Twitter's rebrand is still in its early stages, so it remains to be seen how the company will pivot in its rebrand. But from what we currently know, the company could be facing significant trademark and copyright infringement liability. Ultimately, there are very valuable lessons that companies and brands can glean from Twitter's efforts to pivot to its fresh brand. These include: one, taking your time in the rebranding process. It is important that you conduct due diligence to ensure that your proposed design or company name is not already owned by someone else. And this will ensure that you avoid trademark infringement liability in your rebrand process. The second is that you want to be sure to evaluate the value of your existing brand before you get too far into the rebranding process. You may find that by evaluating your existing brand, that you have invested significant resources and time into your existing brand, and that can inform your business decision of whether or not to move forward with the rebrand. And lastly, that you consult with an intellectual property attorney before adopting a trademark or filing a trademark registration. An intellectual property attorney can provide you with the proper guidance and advice to navigate the intellectual property terrain and ensure that your rebrand has a smooth transition. We hope you enjoyed this episode of DW Fast Track. Be on the lookout for our next episode of all things legal, admissible, and trending, or visit our website at www.dickinsonwright.com.